in South Africa. And I am also an ambassador to the Magna Carta Observatory, and it is in this function that I moderate today's event on academic freedom as a human right. Let me just do a bit of housekeeping. May I please ask all our attendees to just switch off their microphones, unless, of course, you have the floor. We've got a question and answer session later on. And you will already have noted that this session is being recorded and will be available online sometime after the event. Our program today, we are going to speak about academic freedom, what it is, but more in particular, whether academic freedom is actually a human right. So when can we say that academic freedom would be a human right? What would be the advantages of an approach of seeing it as a human right? Could we then deduce certain entitlements from that? Is academic freedom as a human right different from academic freedom as a practice in universities? Does it go further, or is academic freedom in practice actually a broader concept? So just let's think a bit about these issues together with two highly qualified speakers today. We have with us Professor Helle Porsdam from the University of Copenhagen, and Professor Vicky Costas from the University of Leiden. I will introduce both speakers in more detail later on. But as a way to get started, and here I would just like to share my screen with you, my PowerPoint. So I hope you can all see this slide. So you might know Stanley Fischer's book, The 5 Versions of Academic Freedom. So he presents these 5 schools, and maybe as a way to carry us through the seminar, if we were to recognize academic freedom as a human right, would it help us decide which of those schools does actually have a normative backing and for that reason has some credibility or validity? Now let's just quickly go through these schools. Of course, Stanley Fischer himself believes that it is the first school that is applicable. It's just a job school. You need academic freedom to properly teach or to properly do research as an academic, and that is it. So because he just believes in the first theory, it means he regards the other 4 theories a bit in a disparaging manner. The second theory is for the common good school, which says, well, academic freedom just is not only a professional freedom, but it also has to do with achieving a broader goal, like saying, well, it is important for democracy or things like that. Authors I could trace in this school are, for example, Terence Carrin, who thinks that academic freedom has to do with producing economic prosperity, but also in actually enabling citizens in a state to have some broader view and to become like active citizens in bringing about change. Robert Post, who says, well, there are various views in a society, and it should not only be those of government that are valid, but academics bring in their expertise, and from all of this, the truth emerges. So the truth theory is very strong. You also see that, for example, with Olivier Beau from France, who thinks in the virtue of the truth as something broader than a mere professional freedom. Third and fourth school are a bit similar. The third one of academic exceptionalism, Simon Margeson has said the university is an exceptional institution, meaning that academic freedom is perhaps also like a bit a broader freedom than, for example, freedom of speech. the academic freedom as critique school. So Judith Butler believes in this. She says, well, usually we say academic freedom means you may speak within the parameters of your discipline, but she says sometimes we must actually also go beyond these, because otherwise we will not achieve new knowledge. And then the last one is the academic freedom as revolution school, for example, Pierre Bourdieu or Henri Giroux. I've just got a second slide here. This is taken from a piece by Pierre Bourdieu, where he asked the questions: can intellectuals, and especially scholars, intervene in the political sphere? Must intellectuals partake in political debates? So saying it is not just about, discovering the truth, but academics have a much broader function, and for that they need academic freedom. And now, if academic freedom has some form of basis in human rights, maybe it actually covers that dimension, then it would have a strong normative basis. So these are the questions we are going to think about today. And on that note, I'm actually going to stop sharing the screen and introduce our first speaker today, who is Helle Porsdam, Professor Helle Porsdam, Professor of History and Cultural Rights, and holding a UNESCO Chair of Cultural Rights at the University of Copenhagen. She holds a PhD from Yale University in American Studies, and she has held fellowships at Harvard Law School, the University of Cambridge, and the University of Munich. Between 2011 and 14, she was a Global Ethics Fellow with the Carnegie Council for Ethics in International Affairs. And in 2021, she was a Lever Hume Visiting Professor at the University of Cambridge. So I know Helle is a very active academic and a doing person. She publishes a lot, and she's recently published 3 books. I've at least had a look at The Right to Science Then and Now, which is an edited volume where a number of people active in the field of the right to science speak. And Helle is today going to speak about the relationship between the right to science, scientific freedom, and where academic freedom perhaps fits in. Helle, the floor is all yours.
Thank you so much. And thank you so much for having me. Can I share screen now? I can share my screen with you, I hope. Let me try. I am told that the host disabled participant screen sharing. So
I think
yes, you are. You are.
I can now. Okay, yes, here we go. There we go. All right. There are 3 parts to my comments today, and I want to start by talking about academic freedom, what it is, where it comes from, just very briefly historically. And then I want to move on to discuss 3 different justifications that scholars have offered for why it is that academic freedom is so important. This is more or less along the lines of some of the things that Klaus Beider already shared with us. The third of these justifications is actually that academic freedom is required by international human rights law. And this then takes me to the third and last part of my talk that concerns scientific freedom and the human right to science or scientific freedom as a constitutive part of the human right to science. So what is academic freedom? Well, I'm using David Kai's 2020 report when he was still Special Rapporteur on the promotion and protection of the right to freedom of opinion and expression, because I think he actually offers a very nice definition of what academic freedom, how it should be understood, namely to include the freedom of individuals as members of academic communities or in their own pursuit to conduct activities involving the discovery and transmission of information and ideas, and to do so with the full protection of human rights law. So where does the notion of academic freedom come from? It goes back a while, but what scholars often mention is the German research university as it was developed in the late 18th and early 19th centuries. And here Wilhelm von Humboldt played a really important and decisive role, and many of you will have heard about this already. But as von Humboldt saw it, academic freedom had 3 parts. One of them concerned Lehrfreiheit, the freedom of teaching on the part of university professors. The second one concerns Lernfreiheit, which is the freedom of learning for students. And the third one concerns Freiheit der Wissenschaft, which means academic self-government, that the political powers that be should not interfere in the kind of academic self-government of universities. His thoughts, more or less, in my opinion, found their way into the German constitution, where Article 15 says, arts and sciences, research and teaching shall be free. So academic freedom grants freedom to academics, which is not enjoyed by other individuals, other professions. And of course, this has to be justified. And there are at least 3 different kinds of justification, overlapping slightly with what Klaus Beider started out by telling us. The oldest one is that is the epistemological argument that academic freedom is necessary for scientific progress. This is the academic, part of the Bourdieu academic freedom thing. It's necessary for scientific progress and for finding essential new knowledge. And major scholarly breakthroughs, importantly, cannot happen without this. And it's impossible at any given time to actually say which of the breakthroughs that are made will have a long-lasting impact. We cannot know that on beforehand. Now, the second justification I want to mention is that this is necessary for democracy. Academic freedom, without academic freedom, we will have no true democracy. And it's also necessary for educating the future democratic citizen. So education comes in here. An unbiased understanding of evidence-based and evidence-informed knowledge is needed to judge politically charged topics. And in a democracy, you would want members of the public to have this kind of understanding. And it's this that then makes academic freedom or turns it into a public good. And here you can think of the public good school out of Stanley Fish's 5 schools. Again, I'm using a quotation from David Kai's 2020 report, where he notes that without academic freedom, societies lose one of the essential elements of democratic self-governance, the capacity for self-reflection, for knowledge generation, and for a constant search for improvements of people's lives and social conditions. The third justification then concerns the requirement by international human rights law. And again, you remember the first quote I used from David Kai, where he says that all of this should happen with the full protection of human rights law. But this talk of with the full protection of human rights law is all very well and good. But the thing is that there is no single exclusive international human rights framework for academic freedom. What we have is this, which is important. There's some protection in the UN system, and I'm sure that the other 2 speakers later are going to talk more about this too. But there's some protection in the UN system, in the International Covenant on Civil and Political Rights. Article 18 talks about freedom of thought, conscience, and religion, which can promote and protect academic freedom. And then in the other covenant, the one on economic, social, and cultural rights, Articles 13 talks about the right to education, and Article 15 talks about the right to scientific advancements, or what I'm going to call from now on the right to science, both of which expressly promote rights at the center of academic freedom. In the European system too, we can mention Article 9 of the European Convention on Human Rights, which concerns freedom of thought, conscience, and religion. And then in the EU Charter of Fundamental Rights, Article 13 talks about academic freedom, which must be respected, and Article 14 on the right to education. So a certain overlap between the 2 systems. Zooming in now on Article 15 of the International Covenant on Economic, Social, and Cultural Rights, one of the articles that I just mentioned, this is where I get to scientific freedom and the right to science. Scientific freedom was actually what we call abbreviate, just to the wording of scientific freedom, was actually mentioned in the Universal Declaration of Human Rights in Article 27, which says that everyone has the right freely to participate in the cultural life of the community, to enjoy the arts, and to share in scientific advancement and its benefits. There's a second part of it too that I won't go into right now. This, what you have on the left here on the slide, is a woodcut. I don't know whether any of you have seen this before, but this was Brazilian artist Otávio Rode, who in the 1970s thought that the Universal Declaration of Human Rights was a God's gift to humanity and was worth honoring. And so the way in which he did it was to create woodcuts, one for each of the 30 articles. And the one we have here is Article 27. The whole series is available for everyone to see in the UN building in New York. So some of you may have actually seen these beautiful, beautiful woodcuts. Now, the right to science is classified as a cultural right. And this is something that I describe in my latest book, which is called Science as a Cultural Human Right. And the thing about Article 27 also that's important here in our context is that it's repeated by Article 15 of the International Covenant on Economic, Social, and Cultural Rights. And that's the one that those of us who are interested in the right to science primarily work with. Article 15 of the International Covenant on Economic, Social, and Cultural Rights has 4 parts. The first part of the article talks about the recognition of the enjoyment that everybody has of the benefits of scientific progress and its applications. And then the 3 other parts of Article 15 concern the obligations that states parties have toward making sure that that citizens have the right to science. 15.2 concerns the dissemination of science, that there is an obligation on the part of states parties to conserve, develop, and disseminate science. Article 15.3 is the one that is really important to us, which makes it an obligation for states parties to respect the freedom that is indispensable for scientific research. And then finally, the 4th part of 15.4 says that states parties have to recognize the benefits of international contacts and cooperation in the scientific field. And in my new book, Science is a Cultural Human Right, I argue that we should perhaps read this article from the bottom up, starting with 15.4, because without inspiration and without input from fellow scientists, from citizen scientists and others around the world, individual scientists and their research groups will have none of those original ideas that actually lead to progress, short or long term. Their scientific freedom will not result in a pursuit of new ideas as a consequence, and there will then be nothing to disseminate, and therefore nothing for the public to benefit from and share in the end. So scientific freedom is a constitutive element of the right to science. It's specifically protected, as I said, in Article 15.3, and without scientific freedom, there will be no scientific progress from which everybody can then benefit. But as foundational as it is, in order for the right to science to work as intended, scientific freedom cannot work or stand alone. It's only when all 4 parts of Article 15 of the Covenant play together that scientific progress and its applications actually become the kind of global common good that was envisaged by the drafters of both the Universal Declaration of Human Rights from 1948 and the International Covenant on Economic, Social, and Cultural Rights from 1966. So what is then the relationship of scientific freedom, Article 15.3, to the dissemination of science, Article 15.2, and to international collaboration mentioned in Article 15.4? Well, in order, as I said, hinted at before, in order to produce the kind of international, groundbreaking, excellent research, whether it's basic or applied, that the dissemination to the public must be based on, individual scientists need access to scholarly results achieved by colleagues around the world. In order to stand on the proverbial shoulder of giants, scientists have to know what's going on in other parts of the world. And this is where that obligation of states to recognize the importance of international contacts and cooperation in the scientific field, which is outlined in Article 15.4, becomes very relevant. Much more could be said on this issue. We could talk about science diplomacy, for example, but I want to use my remaining time to discuss instead the relationship between scientific freedom and the dissemination of science, which is mentioned in Article 15.2. Who should actually do this dissemination? Should scientists themselves be prepared, perhaps even educated, to let the public know what the results are of their research? Or should we say that it's better professional science journalists do this because they're better equipped to do this? Most scientists we know consider responding to journalists a professional duty, something they simply have to do. But the thing is that entering into dialogue with the public is a very challenging thing to do, as scientists typically have no formal training in science communication at all. And a lot of them have watched colleagues getting into all kinds of trouble when they attempt to share their science openly, especially when public venues such as the social media are involved. Because as we all know, in these media, it's easy to twist arguments, to willfully misunderstand, and to turn against people. And it can be painfully exhausting to try to point out interpretations and to defend arguments. So aware as they are of their own inadequacy as communicators, some scientists then seek the help of professional science journalists. And this is in many ways an obvious solution because these journalists, again, are trained, they know what they do, and they can help bridge that important gap between scientists, policymakers, and the public. And I want to argue here today is that as science journalists attempt to avoid jargon use and to increase straightforwardness in scientific communication, accuracy and important details may get lost in the process. And inaccurate arguments cannot be countered directly and on the spot the way they could be if the scientist, him or herself, were present. And also, science journalists may not necessarily prioritize or get across to the public the excitement that is entailed in the generation of knowledge, which is, after all, the core function of science. So there are certain problems with this, I think. And then there's also another thing. In an attempt to find a solution to the crisis of trust in science, the focus among science journalists and science communicators in general is no longer, at least sometimes, so much on the communication of knowledge, but rather on improving the relationship between science, scientists, and the public. And providing entertainment, perhaps good experiences for the public, seems to have become a goal in itself for some of these communicators, who then forget that plain dissemination of knowledge, remains a very, very important function of science communication. If it all turns into entertainment, into giving the public a good time, then the core function of science, then we tend to forget that the core function of science is creation and the provision of knowledge. That is no longer communicated. So when less attention is paid to the actual communication of scholarly knowledge, the pursuit of knowledge and truth that the framers of the Universal Declaration and the International Covenant on Economic, Social, and Cultural Rights saw as the main objective, we know that from the Travaux, they saw that as the main objective of the right to science, it will tend to recede into the background. So in my opinion, scientists need to be actively involved themselves in communicating to the public what their science is all about. This doesn't eliminate the need for professional science journalists at all, because in order to honor the promise of Article 15.2 and its importance for the right to science, scientists could still very much benefit from being coached by professional science journalists who can show them how to engage with the public in a respectful and non-paternalistic or elitist way. And this is really, really important, I think, at a time when the public becomes more and more involved in science policy decision-making, and a scientific career may depend on achieving public and political backing of one's research. Then communication skills need to actually, I think, be included as a part of educational curricula in STEM and also other university disciplines. And finally, and this is going to be my last slide and my last point here, scientific freedom means freedom to test and to argue, but we should never forget that it doesn't mean the right to force one's results on others. So how can scientists learn to engage with the public and to honor Article 15.2 and its demand for scientific dissemination in a respectful and non-paternalistic way? And here I think we might actually learn something from US Supreme Court Justice Elena Kagan. Now, this is a totally different context, of course, but I still think that what she is trying to do is really, really important. She's using her dissenting opinions to present legal complexities without legalese. And what she does is that she addresses her opinions to other Americans as fellow citizens and stakeholders in American democracy. So we're in the same boat, kind of. And Lincoln Kaplan, who wrote a portrait of Justice Kagan recently, put it in this way, that most outstanding writing by justices still needs unpacking with definitions of terms, explanations of precedents and the like. She does the unpacking. Her writing sounds like she's talking in plain terms and relatively short sentences that a non-lawyer can grasp. She's clearly a gifted writer, is Justice Kagan, but just as importantly, she doesn't lecture, she doesn't talk down to the public. Instead, what she does is that she addresses them as fellow stakeholders, as I said, in American democracy. And this, I think, is really crucial in a political environment such as the American that is divided to the point of being toxic, and where the word elitist doesn't warrant respect at all, but instead seems to have entered the culture wars as a populist signal of criticism against those who think that they may know better than everybody else. So how to avoid that kind of hated elitism in a populist day and age? That's one of the major tasks, in my opinion, that we as scholars and scientists currently face, not just in the US, but around the world as a whole, when we attempt to engage with the public and to honor Article 15.2 and its demand for scientific dissemination as a part of our scientific freedom and as a part of the right to science as a whole. And this is where I'll stop. Thank you.
Thank you very much, Helle, for these insights. You're not only an active writer, but you're also very punctual. You just spoke for the 20 minutes, but it doesn't mean that there is not more chance later on to answer questions and to perhaps say a few more words on some of these issues, because they can get quite tricky. The communication of science, so we know that we've got some academics who are very vocal, also on social media, which sometimes is perhaps a good thing, but universities sometimes also don't like it, brings them in conflict with institutional policy, and institutions these days perform risk management. You know, it's also a business in the end, and business is perhaps the key word for our next presentation. Vasiliki, we call her Vicky Costa. Just a few words on her biography. She studied law at King's College London, obtained the LLB in 2006 and the LLM in European law with distinction in 2007. Thereafter, she pursued her PhD research at the European University Institute in Florence on fundamental rights in internal market legislation. In 2011, Vicky was a stagiaire at the Court of Justice of the European Union, and she completed a traineeship at the EU Agency for Fundamental Rights in 2011-2012. In 2013, Vicky defended her PhD thesis on fundamental rights in internal market legislation at the European University Institute in Florence. She was an Emile Noël Fellow at the Jean Monnet Center of NYU in 2017. And in July 2021, she was awarded a Dutch research grant, a VD grant for the project, the European Union Fundamental Right to Freedom of the Arts and Sciences, exploring the limits on the commercialization of academia. She's an associate professor of European law at Leiden University. And I coincidentally came to know about Vicky's project on commercialization. And I think it is crucial because when we think about academic freedom, we tend to think about authoritarian regimes like perhaps, Iran, or also illiberal democracies like Hungary, where we've got political oppression of academic speech because academics do not comply with, the official version of the truth. But we must acknowledge, and I always call these academic freedom violations 2.0, violations of the second generation, which we actually witness in democracies. And that's the commercialization and its effects on academic freedom and ultimately, therefore, on the production of science. And I know that Vicky will be speaking on this topic today, specifically from the perspective of the European Charter on Fundamental Rights and on Article 13 of that Charter, academic freedom in the European Union. Vicky, the floor is all yours. May I just quickly say, dear participants, if you've got questions, please pose these in the chat. We'll address some of them at least in the Q&A session later on. Vicky.
Thank you very much, Klaus. Thank you to all participants for tuning in. It's really an honor and a pleasure to be with you here today. I'm going to try to share my screen now. Share. Can you all see my screen? Yes. And then play from start. So as Klaus said, I would like to focus today on academic freedom in the EU Charter of Fundamental Rights. So it's true that my longer term research project is to find out to what extent this phenomenon of commercializing academia might be violating the Charter, or to put it differently, to what extent does the EU Charter and its protection of academic freedom pose limits to the phenomenon of commercialization. But in order to do that, we first need to understand what academic freedom in EU law actually means. And so this is what I would like to focus on today. And this is also the first part of my research that I have to do. So to make it also a bit more practical, I would like to really essentially talk about the content of Article 13 of the Charter of Fundamental Rights, as that is not so obvious. And then very briefly at the end of my talk, I would like to say a couple of words on the scope of application of the Charter, as that is again very important for practical purposes. When can we rely on the Charter at all? And so there might be non-lawyers, non-EU lawyers amongst the audience. So I would like to flag that too. But now starting with the content, so it was mentioned already before by Helle, in Article 13 of the EU Charter, we have the following provision that says the arts and scientific research shall be free of constraint. And then the second sentence, academic freedom shall be respected. Now, it's a very short provision, as is typical for constitutional provisions, and it has to be given meaning. Before we go into that, just by way of background, it results from secondary literature, looking a bit into the history of drafting this, that there was debate actually in the convention drafting the charter, the participants of the convention, the drafters, as to whether there should be actually a separate right on academic freedom at all. So it was not obvious that this separate right would be included. It turns out that there was quite some German influence. So it was apparently the German delegation that managed to convince the others that it would be important to have a separate charter right. And that may not be surprising. In the German legal order, we have a long history on academic freedom and quite sophisticated thinking behind it. But that is not to say that this Article 13 merely relies and derives from this German thinking of academic freedom. At the time the charter was drafted, there was, you could say, there were constitutional traditions common to the member states where academic freedom was also present. So maybe not all constitutions, but quite some constitutions had that right also enshrined in one way or another. And it can also be derived from international law. And I believe that Klaus will be talking about that. And this is important for EU law because in EU law, in EU fundamental rights law, the court has always looked at the constitutional traditions common to the member states and international law to give meaning to an EU fundamental right. So we have this charter article on academic freedom, but it has been really under-investigated for the longest time. So if you look at the European Commission's annual reports on the Charter, on how the Charter is implemented in EU law, you won't see any attention to academic freedom. Same for academic literature. EU law scholars really very little debate on this. And this has all really changed with the Central European University case. So both the case being very prominent in the public, but also an actual case coming in front of the Court of Justice of the EU. So this is the Commission and Hungary case, or otherwise also known as Lex EU. So most of us here will know about the case. So just briefly to recall, it concerned an amendment of a law, national higher education law in Hungary, where Hungary, the Hungarian government introduced basically two requirements. An institution, a foreign institution that was accredited in another state would have to operate a campus in another state. And there also had to be an international agreement, a prior international agreement between the home country and the host state. So because in the public, this was called Lex EU because it was pretty clear that this law targeted actually the Central European University. So the European Commission brought infringement proceedings against Hungary. And what is notable in the judgment is that you'll see long passages on the GATS, on alleged violations of the General Agreement on Trade and Services, and on the EU's own free movement provisions of the internal market, so the freedom of establishment and the free movement of services. And at the end of the judgment, you'll see shorter passages on the EU Charter of Fundamental Rights, so alleged violations of Article 13, academic freedom, Article 14.3 on the freedom to found educational establishments, and Article 16 on the freedom to conduct a business. So this is the case where for the first time the court tries to put some meaning to Article 13, the first time it has to adjudicate on this article. And how does the court start? It starts by looking to the European Convention of Human Rights. And that is not surprising. So it's not surprising because it's longstanding case law that the court would look at the convention as a special source of inspiration among all the other international law sources, but also because the Charter itself includes an obligation to look into the convention to the extent that there are corresponding rights between the Charter and the ECHR. At least the same level of protection as the ECHR guarantees has to be then also guaranteed under the Charter. But the Charter can also go above that. So that's the first reason why it's not surprising that the court starts looking at the convention. And in the convention, we don't have a special right on academic freedom, but elements of that are protected under Article 10 ECHR. The second reason why it was not surprising that the court started by looking at the ECHR is because the explanations to the charter, which the court has to duly take into account when it adjudicates on EU fundamental rights, these explanations say that Article 13 and the rights deriving from Article 13 is deduced primarily from the right to freedom of expression. And it has to be exercised with regard to Article 1 of the Charter, human dignity, and may be subject to limitations authorized by freedom of expression, right? So by Article 10 ECHR. So when reading that, one might think that that's then all that the Article 13 protects. And indeed, it does protect the elements that the ECHR has included in its case law as being protected under Article 10. So we have this individual expressive freedom dimension included in Article 13. Academic freedom and in research and in training should guarantee freedom of expression and of action, freedom to disseminate information, freedom to conduct research, and the freedom to distribute knowledge and truth without restriction. And that is not restricted to academic or scientific research, but extends to academics' freedom to express freely their view and opinions in the areas of their research, professional competence, and expertise. So the court here even cites the case law from the European Court of Human Rights. All of that is included under Article 13, but there is more. Article 13 is broader, and the way the court arrives at that, following the Advocate General, is to say, well, Article 13 is a separate right. It exists next to freedom of expression, and that means that there should be more protection. So what the court recognizes here is next to this freedom of expression dimension of academic freedom, also an institutional and organizational dimension. And it does so by citing principally two instruments, soft law instruments. So the Council of Europe Recommendation 1762 on academic freedom and university autonomy, and the 1997 UNESCO recommendation concerning the status of higher education teaching personnel. And what it takes from these two instruments is the following. They basically say, well, you need an organizational structure. The link to an organizational structure is a prerequisite for teaching and research. That derives from the Council of Europe recommendation, but also from the UNESCO recommendation, which states that autonomy is an institutional form of academic freedom, and it's a necessary precondition to guarantee the proper fulfillment of the functions entrusted to higher education teaching personnel and institutions. So the institutional dimension is a precondition for exercising the individual dimension and the expressive dimension. That's what the court says here. And I'm wondering whether this logic actually can be used to feed back from the Court of Justice of the EU to the European Court of Human Rights. So to say, since the European Convention of Human Rights protects expressive freedoms, so an individual dimension of academic freedom, and because these can only be exercised if you also guarantee the institutional organizational form, can that be a way of reading into the European Convention of Human Rights also this obligation? So this is one element. And the other element that the court takes from these international sources is to say that member states are under an obligation also to protect higher education institutions from threats to their autonomy coming from any source. That means that governments should not just negatively, not interfere with academic freedom and violate it, but they should be active, positively taking measures to protect higher education institutions. So therefore, what we know now, what Article 13 protects is an individual dimension linked to expressive freedoms, this institutional and organizational dimension. And in this case, it is clear that the court says you can't just deprive universities of their organizational structure, because that is what was the case at, for the CEU here. But the question is, what about other further elements that can be read into the institutional and organizational dimension of academic freedom? So it results from various international instruments, but also national constitutions, that self-governments, and including the participation in decision-making, is important. That you can have elements such as determining admissions criteria, codes of conduct, recruitment of academic staff, and so on. So sub-elements of the institutional and organizational dimension of academic freedom. Are these all protected by Article 13 of the Charter of Fundamental Rights? Well, we will have to wait for further case law to develop here. So bit by bit, I think there will be more knowledge being gathered on this as case law may develop. And so the third element is that of state obligations. We also know that Article 13 includes that. In this case, the court found an unjustified restriction of academic freedom. As we all know, there was a violation found. An element that I think is interesting to understand what Article 13 then actually protects. When it comes to finding a restriction, the court found that there was a restriction because the national law was capable of endangering the academic activity of the institutions concerned with Hungary, and therefore of depriving the universities of the autonomous organizational structure that is necessary for conducting their research and educational activities. So the standard is that of capable of endangering. You don't need the actual endangerment yet in order to find a restriction. And I think that probably links to this idea that once a situation of uncertainty is being created, that is already enough to find a restriction, which then in this case was also held to be unjustified. Hungary tried several arguments to justify this restriction: public order, avoiding fraudulent practices, ensuring quality, and so on. But all these arguments were not persuasive for the court. Now, one element that I found interesting in this case, and that I wonder about in trying to understand what Article 13 protects and how it does so, is its relationship with Article 14 on the right to found educational establishments. So in this case, it's interesting that the Advocate General and the court diverged on this point. The Advocate General basically stated that Article 14.3 of the Charter protects the institutional framework of universities only for private educational establishments, whereas Article 13 completes this protection for public ones. The court, on the other hand, again, referring to the explanations to the Charter, says no, actually, Article 14.3 relates to both public and private educational establishments. So here the question that I'm wondering about, what is the relationship between the institutional dimension of academic freedom in Article 13 and the protection of the institutional framework in Article 14.3 of the Charter? So perhaps that will be further clarified in future case law as well. And now coming to my last point, when is the Charter actually applicable? When can we rely on the Charter and on academic freedom? And here we have Article 51.1 of the Charter that is important. EU institutions are bound by it and therefore are also bound by academic freedom in Article 13 in all of their activities, in whatever they do. But member states are bound by the Charter only when they act within the scope of EU law. And so what does that mean? They are bound when they're implementing or enforcing an EU measure. Let's say they're transposing an EU directive into national law. Or they're bound when they're derogating from EU rules or restricting an EU right. And this was the case here in Commission in Hungary. And this is the reason why the court starts with the trade aspects of the case. So Hungary was restricting the freedom to provide services, the freedom of establishment. That element was what brought the situation within the scope of EU law. And only because of that element, the court then could also talk about Article 13 of the Charter and find a violation. And there is a third category. I'm not going to go into that, but it's important to note that the court has actually extended this idea of being within the scope of EU law. So the Charter applies also when EU law places one or several specific obligations on member states, or when the national situation is covered by a specific rule of EU law. But the important point here, I think, to note is you can't just invoke the Charter in EU law. You can't just invoke Article 13. You first need to bring the situation within the scope of EU law. And that brings me to the end of my presentation. I will stop sharing the screen. I hope that works. Yes.
Thank you, Vicky, very much for that. Well, obviously, EU law is very important in the European Union. The good thing is we have human rights regimes which specifically focus on human rights, which of course make it possible for individuals to directly approach that, usually only after, exhausting the national remedies. But thank you for that. And there is actually a question for you in the chat. We'll talk about that also later in the Q&A session, but maybe meanwhile, you could have a look at that and see if you can come up with an answer to that. Now, surprise, surprise, the last speaker today will be myself. And it is actually good that we have had two excellent presentations, and the speakers have said many things that I might have said. So I'll leave out those things. As for my own biography, very shortly, I hold a PhD. I wrote on the right to education in international law. I did a Marie Curie Fellowship at the University of Lincoln in the UK, focusing specifically on academic freedom. And the interesting thing is this perspective which Helle has presented today of the right to science makes it much more easy for me to provide a valid foundation for academic freedom and also scientific freedom in human rights, as I shall explain later on. I am a professor of law at Northwest University, where I teach intellectual property law, socioeconomic rights, and international social justice. I am a member of the Consortium for Human Rights Beyond Borders in Heidelberg and an advisor to the Global Right to Education Initiative in London. And my talk today focuses specifically on academic freedom as a human right at the international level, looking at the international human rights documents. Of course, Helle has done so already, but maybe I can add some further perspectives there. I will share my screen now. Okay, there we go. Actually, I am going to skip my first slide on the historic development of academic freedom, because we've heard about that. Just perhaps to note that we do have two separate developments. So we have the development of what in German we call Wissenschaftsfreiheit, freedom of science, and separately from that, academic freedom. So there are differences between these two concepts. And it is maybe important to appreciate that there is this difference. And from my point of view, academic freedom really is the freedom of science as it applies within the university. We should appreciate that science is also done beyond the university. In fact, most of science is done beyond the university. At least 50 or 60% is done in businesses. Science is also done in non-university research institutions. And the freedom scientists should enjoy there may legitimately differ for various reasons. But what I'm going to focus on today is really trying to make the connection between academic freedom and human rights. Why should it be protected as a human right? Because we find various authors that say academic freedom is not a human right. Now, the big question is academic freedom a human right? For that, we obviously need to know what is the purpose of a human right? When do we have to deal with a human right? And the answer to that is the protection of dignity. Why do I say that? If you have a look at all the international human rights documents, Universal Declaration of Human Rights, the international covenants, they all start in their preamble by saying, because humans have an inherent dignity, now therefore we protect the following human rights. Why do we have a right to food? Because that is a requirement of dignity. Why do we have a right to water? Why do we have a right to freedom of expression? Because that is a requirement of dignity. The question then obviously will be, is academic freedom a requirement for dignity? And that, on the face of it, is difficult to answer, but the moment we appreciate that academic freedom really, as part of the right to science, is part of this construct, which we call the right to science in Article 15, then we understand how human dignity is implicated. As Helle has said, there is a positive and there's a negative dimension. So the positive dimension is the right to enjoy the benefits of scientific progress. That is the right of citizens around us. So it creates an obligation for states to somehow create a science system where there is science coming out of that, which makes possible progress. And in order for such progress to happen, there must be some people doing the science. So that is where the scientists come in, and the scientists, that is empirically proven, can only do proper science if they have freedom of science, if they have academic freedom in universities. So in this sense, academic freedom really is a requirement for the human dignity of all citizens. It might be an instrumental way of looking at it, because it means that I, as the academic or scientist, actually am there to protect the dignity of others. In German constitutional jurisprudence, you find the concept of a drittnütziges Grundrecht, meaning a foundational right for the benefit of others. In a way, it is like that, not only, but that is a very strong component of it. If we find it too instrumental, we might have a look at Ronald Dworkin, the legal philosopher, who says, apart from this truth-finding mission, there is also the ethical component, in the sense that once there are academics or scientists producing knowledge, it actually makes it possible for the whole population, to have access to that knowledge and to make decisions about their life. It creates a possibility to choose a life. And that has got a very strong ethical component. Then it's not just a pure finding of the truth for progress of science. But still, we are lacking the dignity of the scientist, him or herself, perhaps, in that. And here I found a very interesting source by Alia Shaver, who writes on the right to science. And there she says that inherent in the scientific progress is a value for the person conducting science. So she says, in the same way that doing arts or literature is a way of expressing parts of our shared humanity, doing science is a way of expressing that humanity. So in that sense, academic freedom, scientific freedom is important for the dignity of the scientist academic as well. That is how I would construct the basis of these freedoms in human rights law and in the dignity. Now, to say a few words on the difference between rights to freedom of science and academic freedom. I've said something on that just to show that I'm not alone on this. If you read Eric Barrett, Academic Freedom and the Law, there he says, so I'm quoting from the first paragraph and read, academic freedom as it is understood in the UK and the US is, in contrast to freedom of science as the broader concept, a special right to which only those engaged in teaching and research at universities and other comparable institutions are entitled. And this has some implications, because, as I said, science is done in various institutions, but maybe the protection must actually be different. Okay, this is just to confirm academic freedom is the right of academics, staff, and students. It is not the right that you enjoy in think tanks, policy institutes, or related NGOs. It is not the right that you enjoy when you are a researcher in a company. It is not the right that you really enjoy if you are in a non-university research institution. It is difficult sometimes to make a connection or to clearly separate them because there may be elements of both in them, but it shows us, and that is what this slide shows, there is a purpose behind that distinction, and that is the moment you are a scientist working in a university, enjoying academic freedom, it means a certain number of additional things that it doesn't mean in the other context. Namely, the one is academic freedom is a principle for allocating responsibilities, and it is an academic and university organizing principle. So we've got principles of self-governance and institutional autonomy, which do not play a role in private business doing research or in think tanks doing research. These often have a very clear agenda of what research they do. So a scientist cannot claim, I just want to do research on anything. The moment that you're employed there, you know what your research agenda is. In the university is different. Universities really are about disinterested, free research. You choose the topic and the way of doing research. And for that reason, it also means that you have much more leeway of what you're going to say, the science you're going to do, bringing you much more in conflict, perhaps with authority. And for that reason, academic freedom enjoyed in the university needs a special protection, probably a broader protection than you would need in other contexts. You may note I'm just skipping a few slides also for reason of time, but now to come to the second point where I said academic freedom in contradistinction to freedom of science has certain additional components which we do not find in the same way for the broader freedom of science. They are mentioned here in the UNESCO recommendation concerning the status of higher education teaching personnel. And just look at the parts that are highlighted in red. So of course, there's the freedom to study, teach, and carry out research, but then there's also institutional autonomy. And then there is self-governance and collegiality and a security of employment, including tenure. So these are components we should have a look at and see what is the reason for these components. And again, try to find a basis for those, in the concept of dignity. Of course, dignity is always a broad concept and must be concretized, but it is at least like a guideline to follow, to say, why are we speaking about human rights in this instance? We've spoken about the rationale for the protection of individual academic freedom, discovery of the truth and ethical individualism. And you might know Robert Merton has formulated the important rules of science, normative structure of science, where he says the role of the university really is about disinterested science, and that differs from science done in the industrial sphere. And at the moment, we've got a danger that industrial science is actually invading the academic space, meaning that we have less and less really basic research, which is needed for groundbreaking discovery. And for that reason, academic freedom as a freedom to protect this disinterested science is so important. Now, we have already heard a reference to the Erdogan decision. There is a concurring separate judgment, which is interesting because it makes clear that there is a difference between academic freedom and freedom of speech. So now we are actually contrasting these two. The problem is that the European Court of Human Rights just has the European Convention on Human Rights with the freedom of speech. There is no provision on freedom of science in it. But here the courts make it actually very clear that freedom of science, now you will see this paragraph here saying that freedom of expression as an umbrella concept is too broad a category to cover all the dimensions of academic freedom, and that the purposes of these two rights are also very different. Academic freedom in the first instance is about discovery of the truth, whereas freedom of speech really is about democracy. Everybody may view the opinions, and these opinions may actually be false. You even have a right to lie. The US Supreme Court has said the freedom of speech covers the right to lie. Now, as an academic, you never have the right to lie. So it is a very, very specific form of freedom of speech. there are limitations. What is academic speech? So academic speech is also limited by various factors. So when do you enjoy the protection? You must obviously be an academic. You must speak within the sphere of your research, and your conclusions must be based on your professional expertise and competence. And perhaps also look at a quotation from Karl Jaspers in his book on the idea of university. Science means objectivity, dedication to the subject matter, well-considered deliberation. So it is not an expression of just any views that you have. It is a very specific form of speech, also subject to controls that are legitimate, peer review, which would not be legitimate in the context of freedom of speech. There they would constitute censorship. So there are differences. And so it also renounces this claim that academic freedom is like a special privilege conferred on a certain caste of people in academia. No, it is actually more, you could often say it's more of a duty than really a freedom. Now, if we speak about, I'll just say a few words on institutional autonomy and self-governance, because then my time is already also over. Institutional autonomy, what is the rationale for that? So Vicky has already said in the UNESCO recommendation, it is said it is the freedom, the academic freedom of the institution. So this is a statement made here in the UNESCO recommendation, and it is quite important because it shows that institutional autonomy is limited by academic freedom. Its main function really is to protect academic freedom. Institutional autonomy is not a freedom to be used by the institution, to make as much money as it can, for example. No, that would actually often be counterproductive from the perspective of protecting academic freedom. It is not the freedom of the institution to hire and fire, for example. No, because that would be contradictory to academic freedom. So academic freedom really limits institutional autonomy. So just to show that in the European context, the university, now what is this called? The European University Association has produced this chart of what institutional autonomy entails, meaning organizational autonomy, financial autonomy, staffing autonomy, academic autonomy. All of these, in a sense, are correct, but very legitimately, Livu Matai and Julia Iwinska recently say, in Europe at least, there has been progressive change in autonomy, but regressive change in academic freedom. So it means the abuse of autonomy to limit academic freedom. And then they also say there's a tendency to define, measure, and practice autonomy in relation to efficiency rather than intellectual, moral, and legal references, including human rights. So these very technical categories perhaps miss the point of what the institution actually is about and what institutional autonomy really is about. Now, the last thing perhaps to focus on is this thing of self-governance and collegiality, because I think this is perhaps the element that is most severely eroded in universities today in democracies. So what is the purpose of academics being able to play a role in the management of the institution? So self-governance really means management by academics. Now, we know that meanwhile we have got executive universities where it is managers leading the universities, and that may be counterproductive. Also from the human rights perspective, think of those who should enjoy science, the benefits, whose dignity should be protected, because a model where the governance is such that the academics are not really able to, regulate their own science, actually cannot produce good science in the end. I've been relying on the concept of Wissenschaftsadäquanz from German law, adequacy of science, as a concept, because it indicates that decision-making should not be in the interest of efficiency of an institution, for example. It should be in the interest of furthering science. And those two certainly are different things often. An efficient university is often not a university that fulfills its role from the perspective of really advancing science. For example, Paul Feyerabend, the philosopher, says science is essentially anarchic enterprise. interesting book here, The University and the City, where it is said that these slack or redundant resources, practices, organizational forms, and knowledge which we would consider they are not efficient. They are actually the source out of which, the productive source out of which further science arises. You know, and so if I say it is the freedom of academia, of scientists to manage themselves, then it means it is problematic if we have got a clear division between managers in a university and the academics. And the managers, if you do not already follow this tweet here, these tweets by associate deans, you know, I would recommend doing so. This one just recently appeared. No one understands how hard it is to publish in top-tier journals these days. That's why I'm in administration in the university. So, you know, we have got a phenomenon that we've got more and more managers in universities. And, you know, read the second comment there on. Well, those who know how hard it is, they do research. Those who can't teach and those who really can't administer. Kidding, boss. So that is really what self-governance is all about. And it is perhaps the element that is most widely infringed. Now, I know I've got many slides, but I'm just perhaps mentioning, perhaps this last slide here. Regional protection of human rights. Of course, we've spoken a lot about Europe. Academic freedom also is protected in human rights documents. In America, we know that there has been a declaration on human rights by the Inter-American Commission on Human Rights in 2021. In Africa, the African Commission has decided that academic freedom is an important right, considering protected on the one hand by the right to education, but also by the right to freedom of speech. And in Europe, the European Court of Human Rights has produced a number of judgments. And just to say that the European Social Committee, which administers the revised social charter, has accepted a case, Syndicat des Accrédés de l'Enseignement Supérieur versus France, which very much focuses on this concept of also, you know, academic self-governance and collegiality, a case which is yet to be decided. I actually believe that the prominent author of the case being brought is actually in the audience today, so welcome. And on that note, I would conclude my speech. We've got 15 minutes left. We can also go over the time if it is necessary. So now's the time to ask and answer questions. And so maybe to get started with, so Vicky, you might have read the first question. So referring to point 18 of your presentation, meaning that autonomy of institutions overrules the autonomy of individual researchers. The remainder of the question there, and I assume people in the audience have read it. Could you comment on that, please, Vicky?
Yes, Klaus, I think actually you said something that is very relevant to that, actually, that the institutional autonomy is there to serve the academic freedom, right? So, of course, there can be a conflict between the institutional and the individuals, but it should be understood that the institutional is there to serve, right? Therefore, it's a precondition for teaching, education, free research, and so on. So I think that's the element. What makes it interesting here is, she says, not to do any research with the fossil fuel industry. So that would concern ethical considerations. I mean, from the point of view of EU law, I wouldn't know what the answer would be, but maybe Klaus, you would know from the point of view of international law, how that weighs in when the institution sort of wants to comply with certain ethical value standards. It might be even linked to human dignity in the most extreme case. How does that play in a conflict between the institutional and an individual dimension?
Well, Helle, you're welcome to come in at any point. Let's do this as a discussion. Now, I know there are a few statements on ethics produced by various professional bodies, but international law has not really pronounced on that. But I know that there is scholarly writing saying that there is a potential conflict between ethics and academic freedom, in the sense, not that there is not a need for ethics. So ethics, of course, is an important requirement of human rights itself, because it is directed at protection, for example, of the dignity of persons. But there is a danger if protection is too far-reaching, then it actually infringes on academic freedom. Of course, the question is, where do you find the boundaries? But the big danger I think we have at the moment is that institutions sometimes have a very strict ethical review, not so much for the purposes of protecting ethics, but for the purpose of protecting reputation. And that is, again, where we come in with institutional autonomy actually being abused, because this should be about protecting academic freedom. But of course, I cannot give a clear answer to this. And does the EEC Charter apply to EEC member states like Norway? I guess it does.
Well, so when we're talking about the European Economic Area, the Charter, to my knowledge, without being an expert on EEA law, is not as such applicable. But I think EFTA courts are trying to take into account the Charter. The Charter is, in principle, its addressees are the EU institutions and the EU member states. So to the extent that we're going outside this EU law framework into international agreements, then it depends on whether it's been incorporated. And for EEA law, I believe that would not be the case. To be fact-checked.
Thank you, Vicky. I'm just going through the chat here and see. Okay, maybe I'll direct the question at Helle. You've spoken about that, but that concept of science diplomacy is very interesting to me. So do you see a clear grounding of that in the international covenant? Where does that concept come from? Is that a concept that is that your own concept that you've formed through your research?
It's just that that the fourth part of Article 15, which is about the importance and about states having the obligation to make sure that there is collaboration on these issues, you know, might I've been interested in science diplomacy from that angle. And I think also SDG 17, which is about, you know, isn't often talked about, but which is about the collaboration between international partners, is important. And what I was trying to say with the Justice Elena Kagan is that what she has understood, I think, is this need to talk about, especially during times of crisis now, you know, with climate change being a big issue, a global big issue, is the importance of being together on this. You know, we are in the same boat, so we need to work together. And I think it's one of the problems with the two big, you know, the trade wars right now between the US and China. Which take the Arctic region, for example, you know, which interests me as a Dane, because Denmark is one of those Arctic states because of Greenland. So much of those trade wars are about science and technology. So whether or not they want to, scientists do become citizen scientists, I think. And what neither China nor the US quite understand, in my humble opinion, is the need for cooperation. You know, they have to be members of the international community. So science diplomacy, I think, is something that the scientists have to engage in whether or not they want to. Science simply and technology plays such an important role in the world today, and we need it in order to get ourselves out of the current mess of climate change, for example, and certain other global problems that are truly global. So that's what I meant when I said that that Article 15.4 is a really important part of the right to science. I don't know whether I answered your question.
Yes, thank you, Helle. There are two questions in the chat that I'll address now, but before doing so, maybe another question that Helle could meanwhile think about while I answer my question, and that is the right to science. Now, it has a very interesting history. You know, it was drafted a long time ago, and We've not heard about it for a long time, and then suddenly it emerged. So maybe just a bit about what the state of the research is and what propels the research. Why has it suddenly become so important? So maybe you could say something about that. But let me first address the question here about academics speaking in public, what the implications of that are for their speech. Now, there's a very interesting publication made by professors in the LERU, that's an acronym, network, academics from at least University of Leuven, I know, who make a distinction which is very sensible to me between intramural speech, extramural speech, and off-topic speech. So intramural speech is really the academic discourse the academic has with other academics. Now, whether it is within the university or outside the university, but it is with academics. And here, the protection of academic freedom should be very high. So your speech rights enjoy a very high level, because that is in the interest of, furthering that truth that we've spoken about. Now, the moment the academic speaks to a lay audience, but within his field of expertise, then we speak about extramural speech. And here, so I think we should also distinguish that from the categorization used in the US, because there it works a bit differently. But extramural speech really means academics speaking to a lay audience. I think that is also what Helle spoke about quite a lot, making our science known to people outside, where we also have, as academics, a higher level of protection than is covered by usual freedom of speech. But of course, the requirement is the academic speaks within the field of expertise. So, the literature professor talking about the Holocaust is likely not speaking within his field of competence. He might make comments on that, but the moment he or she does, he actually relies on ordinary freedom of speech as enjoyed by all people, then that person cannot rely on academic freedom. That's what we call off-topic speech. And there the protection is the same as for ordinary freedom of speech. So that actually also is the answer. Academics do not, by virtue of being academics, have more protective rights to just say anything about anything. That was one question. Maybe now, Helle, you could come in answering that question that I posed.
I can try. It's a big one.
Yeah, it's a big one.
But William Schabas, who was one of the first researchers to start talking about the right to science and has become interested in this many years ago, talks about the right to science as a sleeping beauty. It has lain dormant for a long, long time. It's been there, as we talked about, it's in the Universal Declaration, but it hasn't really been heeded for a long, long time. And then, 10, 15 years ago, it started becoming, people started really talking about or doing research again on the right to science. And what has the more immediately, I think, within the past few years, what has increased the interest in this particular human right may especially be two things: COVID, and people actually acknowledging that perhaps scientists have something important to say and to do. And along with that, climate change also, we need scientists. And the other one is populism. The way in which, to many people, what scientists say has nothing to do, it's just an opinion like any other opinion. So how do we deal with that? And that's what I do in my research right now. I think we really have to deal with that issue in populism. If the general public says, what do you know? What you know is just one opinion out of many. And a third thing that I wanted to say is just draw attention to, many of you probably know Naomi Oreskes' work, but she in a conference we did in November at the University of Copenhagen on Niels Bohr and his open letter, the Danish physicist Niels Bohr and his open letter to the UN from 1950. She said in her talk there that distrust is not, at least in the American context, is not so much an issue in terms of people distrusting science, but it's what scientists do with it. It's when people feel that their particular values are kind of ruined by science. If you're deeply religious, you will not like evolution. If you believe in states' rights in the American context, you will be more prone toward being an anti-vaxxer, because who is the federal government to decree anything concerning your life? So I think it's many different things that have gotten the right to science out of that dormancy. And today, the next generation, I have a PhD student working on this. I know there are other PhD students working on this. It's about going from theory to practice. How can we start using the right to science in practice? Not so much anymore the normative framework of it, what is it? Many of us have worked on that for a number of years, but how can we use it in practice? Could it be used, for example, for climate change litigation? Could it be used in other kinds of litigation? So that's where we are right now, I think.
Thank you, Ali. That makes it very clear there's a very practical relevance of this. And as I would say, why are we concerned with human rights? Well, it's a dignity of people that is really at stake. We are running out of time, but there's one question I'll have a look at. I'm very sorry if not all the questions can be answered. We are very happy to answer questions subsequently by email or so. But I'll answer one question and then perhaps last question for Vicky. So I'll maybe ask that question already, then you can think about it while I answer one of the questions in the chat. And so Vicky, you're doing this very interesting project on commercialization as an infringement of academic freedom. Is there just one or two points from your research that you can already share with us, your insights, how some of these targets, some of these issues might be targeted, for example, before court of law? While you're thinking about that, I'll answer the question about academic freedom of students. Yes, academic freedom is enjoyed by members of the academy. Now, if you actually have a look at the definition of that in the dictionary, then it says it includes teachers and students. But also if you go back historically, for example, to von Humboldt, then he says academic freedom means three things. It's a freedom to teach. Obviously, that's rather teachers or academics, but there is also the freedom to learn, and that is definitely where students come in. Not only students, but predominantly also students, and the freedom of research. So also students at the later stages of the academic endeavors do research, freedom to choose topics, freedom to choose methods of research, especially obviously if you do master's or doctoral studies, then you're entitled to enjoy that. Malcolm Tite, who's written on academic freedom, says that academic freedom often is a matter of degree. So the scope of the rights that you enjoy really depend on many factors. How far have you advanced in your career? What type of work are you doing? What type of institution do you work at? So it's not always easy to answer what is the exact scope of academic freedom. So there is also a lot of literature these days addressing the topic of whether there is something like academic freedom. And I think it is generally agreed that there is student academic freedom. And now the last question, Vicky.
Yes, Klaus, thank you. On the point of how we might sort of litigate this question of commercialization, I think that would be really hard in the EU context, precisely because you can't just say, I'm bringing a case against a national policy that goes towards commercialization, and the EU Charter of Fundamental Rights, academic freedom, guarantees that this should not be the case, to the extent that there is a violation because of all these constraints within EU law. So in the way I look at it at my project now, the sort of the practical, what can be done to maybe hold commercialization to the extent that it is violating academic freedom, is to look at principally two areas. One is the Bologna process, and that's of course not EU law per se, but the European Commission plays an important role within that process. So to the extent that the Commission might be disseminating certain policies or discourses that we could construe as undermining academic freedom, to the extent that they're construing an idea of commercialization that would violate that, then we could say, you know, the European Commission is actually bound by the Charter and should not be doing that, right? And there would be also this duty on the Commission not to violate academic freedom. So that's one angle where I try to see where practically it may make a difference. And the other angle, potentially much bigger one, is the European research funding schemes, right? So you would have to ensure that these funding schemes are in compliance with Article 13 of the Charter of Fundamental Rights. And the ERC one probably is the one that is the least problematic, because it allows for unbound free science and so on. But then what about all these science schemes that want you to show usefulness, that want you to sort of have an instrumental view on science? Are these problematic? And if they are, they would have to be changed. So practically speaking, these are two angles that I will be looking at more deeply once I've understood better what commercialization is and what academic freedom is, in order to perhaps make some practical statements and recommendations as to how things might change or should change.
Thank you, Vicky. And of course, I'll be your biggest fan to read the articles that you write, because I'm grappling with the same topics. But it's good that this kind of research has started. And of course, we're also waiting for all the interesting further publications that Helle will produce. I mean, she has already produced so many. Please go look them up, read them. So this is then the point where this webinar comes to an end. David Locke, the secretary of the Magna Carta Observatory, has actually privately in the chat said that our two speakers today have added so much depth to the discussion on academic freedom, scientific freedom, the right to science. And I should convey my sincerest thanks to you on behalf also of the Magna Carta Observatory. I hope you all enjoyed the discussion. As I said, it will be online subsequently at some point. You can look it up again. I posted my email address in the chat, and I'll be happy to refer any emails also to the other speakers if you've got specific questions. On that note, thank you, everybody, and we wish you a good afternoon. Thank you very much.